Okay, so hi everyone. Thank you very much for joining us for our lunch and learn today, which we're hoping you're going to find informative and gives you a few takeaways. Talking of which, hope you're going to enjoy your lunch while you're doing the learning bit. So let me just quickly introduce our team today. Obviously, I'm Alison Benney, founder and managing director of enlightenHR. Holly Mapstone is our senior HR business partner, and Debbie Cairns is an HR business partner with us as well. I don't know whether you can actually see April, who's in the background twiddling the knobs and doing all those things. April is one of our HR coordinators. So we're going to cover a range of topics which you're aware of today. It's a challenging time for businesses at the moment. Increases in national insurance costs have had an impact both on job vacancies and on employment in businesses. So I'm sure you've seen that reported in the general news last week. It was fairly inevitable that it was going to put pressure on business costs and that employers would look at their resourcing, because that's the biggest cost, usually one of the biggest costs in the business. So it's also led to us seeing an increase in our clients looking at redundancies, which we're supporting from initial consideration and rationales right through to the implementation, and we provide support across the board with that. Also, where we have a vacancy, a lot of employers are tending to put off recruiting a replacement, either managing the work within the existing team or waiting to see what happens in the next sort of 6 to 12 months. Looking ahead, we've got the Employment Rights Bill progressing through Parliament, which is going to bring in some key changes for employers. Holly's going to cover some of that a bit later. And I'll let Holly pick up now to talk us through the agenda.
Thank you, Alison. I'm just going to note a few latecomers to the meeting. So, yeah, following on from the introduction that led to you being in the webinar today, this is the agenda that we're going to cover today. So, about kind of our trends and what we've been seeing over the last 6 months. We're going to talk about the key takeaways for you today, because you're all giving up your lunch break and snacking away in the background, hopefully. But we want you to take away some real practical and pragmatic pieces of information to be able to go and implement those into your business. As Alison said, we're going to talk about how we manage redundancies effectively, how to handle probation periods, particularly around when there's complex employee matters, particularly around medical concerns. We're also going to talk about how to prevent the grievance being filed. We will try to kind of follow up with the Employment Rights Bill and any updates that come from that. And depending on if we've got time, we will cover some recent rulings and Q&A. Could I just kindly ask everybody that's joined if they could just mute themselves, just so we've minimised the background noise? That would be absolutely amazing. Okay, so it's a lot to cover in the hour, and we do want to kind of try to keep a little bit of time for Q&A. So, as I said, what's been hot on our agenda, as you can see from the chart on slides, this is just covering what we've been covering since January, and it's kind of giving you a little bit of a flavour of what's going on within our sort of client pool. And as Alison said, our clients are considering to implement more redundancies this year, alongside terminating employees with under 2 years service. And they're trying to bring that in prior to the October 2026 ruling for the unfair dismissal from a day one right. We've seen lots of disciplinary and performance management being undertaken, and it's increasing as employers are picking up those issues and dealing with them as and when they arise. And it's putting a lot of pressure on management and leaders of the business to kind of do those interventions a little bit quicker and make sure that we're on the front foot with those. And obviously talking to us in the capacity of your HR advisory team helps us support you along that journey. And employees are also under pressure, and they're feeling the stress. So it's also about spotting the signs and understanding from a welfare perspective, identifying if there's any triggers work related. So a couple of statistics up on the screen for you now, which I won't run through, you can kind of read those, but none of those are probably surprising following on from what Alison said. But to be fair, what's been contained within the Employment Rights Bill is best practice. And the challenge for employers, particularly smaller to medium-sized businesses is actually to consistently adopt those approaches consistently. You know, we all know that the day job gets in the way of, you know, the other key tasks that you may have. Costs will see increase, such as SSP from a day one rather than day 4, and managing that sickness absence will also be top of the agenda when we move forward in terms of the legislation changes. Alison had a meeting with one of our clients, and they talked about actually the substantial impact that it's been in terms of maintaining those return to work interviews. 3 big advantages of having Alison and us there in terms of those is, one, kind of keeps them on track in terms of actually making those return to work meetings happen. The employee journey is managed fairly and consistently, and whatever the outcome of that would be, it's in line with the legislation. And secondly, it saves her time and money, and in the long run, you know, mitigates any risk. So in terms of the support that we can offer, it kind of underpins all of these other stress points that you may be feeling from the legislation changes. Key takeaways, as I said today, hopefully we'll run through what best practice of redundancies look like, you know, pitfalls, what to avoid, how to kind of a whistle-stop tour. We're not going to, it's very high level, but just to give you a flavour of what we should be spotting and what we should be doing. Probation management, again, particularly we've seen an increase when people are managing that probation period and there's employees with complex medical conditions, and how does that impact their capability to do the role that you just appointed them in. We're going to be talking about grievances, you know, the dreaded G word, unfortunately, and how we can actually prevent those from being filed and submitted, because it's a huge drain on resource dealing with grievances, and we'll talk a little bit more about that. And then preparing for the employment law changes that we look ahead, and getting you prepared for those challenges in the next coming months. So a lot to cover, as I said. I'll hand over to Debbie now, who's going to cover the redundancies for us. Thank you, Debbie.
Thanks a lot, Holly. Okay, so as Holly was saying, sadly, redundancies have been a growing topic for support over the last 4 months. And I'm going to take you through ACE's best practice for redundancy. So from an employment perspective, redundancy should always be the last option. Before you go down this route, things to think about. Have you thought about natural attrition and a freeze on recruitment? Redeployment of roles to other areas of the business, ending freelance contracts, looking to end fixed-term contracts that have less than 2 years service, ending overtime. So options to consider before you start the redundancy. So what actually constitutes a redundancy? What is the legal definition? So redundancy is usually a type of dismissal when a role is no longer needed because there is a cessation of reduction in the need for work of a particular kind. You should only consider making redundancies if part or all of the organisation is closing or has already closed. You're changing types or numbers of roles needed to do certain work, or you're changing location. But when considering making redundancies, your first step should be to check why you think the redundancy is necessary, what issues are you trying to solve, and are there any other options that might be available? One thing that is paramount here, though, is if you have concerns about an employee's conduct or performance, you need to follow either a disciplinary procedure or a capability procedure. Redundancy could then be deemed an unfair decision if you go down that route because it's performance. So just something to bear in mind. So if redundancy is the route and path that you're looking at, then you really need to consider the steps that are on the slide. So step 1, plan. Put together a plan which you can share with your employees. It will help you follow a fair process and avoid the risk of potential legal claims. If you're unionised, it's a really good idea to involve them in the plan as well. So what should the plan include? All the options you've considered before deciding redundancies are still needed. The number of redundancies you're considering. Think about how you're going to pool the at-risk people. How are you going to select them? You know, so we're looking at people undertaking broadly similar job functions. how you intend to keep staff informed and supported throughout the process, how you're going to consult with affected employees, including, and don't forget, really important, those off work, for example, on maternity leave or sick leave. Don't forget them. It's really important to include them in consultation. Think about the timeframes, leaving enough time for consultation, looking at a fair selection criteria, thinking about your redundancy pay and notice periods. Are you going to stick to statutory, or do you have to look at contractual, or are you going to consider any discretionary payments? And then also at the end, although not a legal requirement, are you going to consider an appeal process for people who think that they have not gone through a fair process? Okay, so next step, we're now at the So you now need to meet with the individuals whose roles are at risk. This can either be in a group or individually. Inform them of the business rationale and show us almost a before and after chart of your restructuring. Important thing to remember, at this stage, redundancy is still just a proposal. Nothing has been decided. So advise them on the consultation process, and that they have the right to be accompanied at that meeting. Now, this at-risk meeting needs to take no more than 10 to 15 minutes. This is not the time to start answering questions about the role and the rationale. That is for the consultation meeting. At the end of that risk meeting, you provide them with a letter outlining the date, place and time of consultation and an explanation of the business rationale and the purpose of the consultation meeting, their right to a companion, and you provide any details, if you can at that time, of any open vacancies that you might have that they can start considering. So step 3, the consultation process. So ACAS doesn't actually stipulate how long this process should be. The only guidance that they give is that it needs to be meaningful. So as a rule of thumb, we generally say 2 weeks, obviously longer if it's more complex. But it's important to remember it's an opportunity for employees to ask questions about your decisions, about your business rationale, and it's their chance to put forward any thoughts and suggestions they might have on ways of avoiding a redundancy situation. So don't dismiss any suggestions at the first meeting. Remember, you need to show that you've had meaningful conversation and you've considered their thoughts. So always, if they've put forward any thoughts, thank you very much, that's interesting, let me go away and consider that. If you have any vacancies, think about discussing these with the individuals during consultation. Would they like to apply for any of those roles? Do they think that any of these roles are suitable? Also confirm the selection criteria and pooling that you've put together. Obviously, if it's individual roles and unique roles, it's not an issue. But if you're getting a team of people together, think about like-minded roles or like-minded work roles. Advise on redundancy. Think of statutory. Are you thinking about any additional payments? And remember, people are only entitled to statutory redundancy if they have 2+ years service. You then need to hold any subsequent meetings, so with the consultation, so that you can offer any feedback that they may have raised. And again, further meetings may be necessary, but as I said, it's dependent upon the complexity of the situation. But at these subsequent meetings, this is when you can start closing down thoughts and ideas. So if they've come up with something, you can say, we did think about that. However, we deemed it wasn't feasible because. So always give a reason why, don't just shut down. Step 4 is then confirming the outcome. So if redundancy is the outcome, there is no alternative employment, there are no ways of avoiding the redundancy, then you need to advise them that their role is being terminated due to a redundancy situation. You provide them with a letter informing them that their contract of employment is terminated. and you explain all the financial payments and when they will be processed. And the letter will also note the appeal process. Now, as I said before, there is no legal right to appeal a redundancy, but it is good practice to allow them to do so. So step 5 is the appeal, if they wish to appeal. Ideally, the appeal process should be handled by somebody else who hasn't handled the actual redundancy. Obviously difficult for very small businesses, and consideration is taken for that. But we are here to support you through all that process. We've got our template letters, briefs that we can provide you so that you have formats to follow. So, redundancy pay. You must pay the legal minimum statutory amount of redundancy pay to employees, as I've said, who've continuously worked for you for 2 years or more. As I said, you can, of course, pay more. That is referred to as enhanced redundancy. You may have this in your contracts. For statutory redundancy pay, how much depends on the employee's age, length of service. Now, service is capped at 20 years. And it's based on their average weekly pay. Now, do remember, average weekly pay will include any commission payments, bonus payments, and overtime. So do have a look at average pay over, top of my head, I think it's the 12-week period. Do have a look at that. What they would get, so this is where it gets a bit complicated, it's 1.5 weeks pay for each full year they were aged 41 years and over. It's 1 week's pay for each full year they were aged 22 or older, but under 41. And it's half a week's pay for each year they are aged under 22. Much simpler way is to go on gov.uk. There is a redundancy calculator. You put in all their information. It will then tell you how much redundancy pay is due. Now, anything that you pay as redundancy pay, and this includes enhanced redundancy, anything up to £30,000 is tax-free. If you're considering paying anything more, then obviously when you put it through PAYE, then it will then be taxed. Next, we consider notice. So again, this is either statutory or contractual, and it's whatever is the greater is what you pay. Now, the notice period can either be worked in full, in part, served as garden leave, or not worked, and you pay it in lieu. So the individual, say, for example, would end on the 30th of June. They've got 4 weeks notice. You would pay them their 4 weeks notice. If you're paying notice in lieu in a final settlement, the employee is not working their notice, you need to consider the length of notice to calculate their final redundancy pay is correct. So, for example, if an employee has worked 8 years, 11 months, they would be entitled to 8 weeks notice, statutory notice. So if we then add on that notice period onto their length of service, it then takes them into 9 years redundancy. Now, if you can't afford to pay redundancy, you can apply to the RPS for financial help. And again, we can support you through that if needed. So the next thing you've now to think about is then also considering suitable alternative employment. If the role is being redundant and you have something within the business that they can consider rather than terminating employment. So you must try and move employees selected for redundancy into other jobs within your organisation instead. As I said, this is called offering suitable alternative employment. You must identify any available jobs in your organisation and talk to the affected employees to see if they are suitable, and this is part of the consultation process. If the role is suitable, then you should offer it instead of redundancy. If you don't, the employee could make a claim at a tribunal for unfair dismissal. They should tell you, as I said before, if they wish to be considered for any role. If there is more than one employee who is interested in the same role, you offer the role to any employees who are either on maternity, shared parental leave, or adoption leave first. And through the Employee Rights Bill coming through, there is a lot of protection for maternity. So anybody that is currently on maternity leave and is part of the pool, they will automatically have a right to look at the suitable alternative roles first. And you follow a fair process for all other employees, for example, holding interviews for the role. When you offer an employee another role, it must be put in writing and offered before their current contract ends. If it's a different role than the one they're currently doing, you'll need to explain how it's different. And you start with 4 weeks, and they can start within 4 weeks of their current role ending. Now, the individual does have the right to a 4-week trial period if they accept a new role. Especially if they need more time to train for the role, you can mutually agree to a longer trial period. But this, again, must be put into writing and have a clear end date. If the new role is deemed to be then unsuitable, the employee can leave in the agreed trial period without having to give additional notice, and they will then receive the redundancy payment. If the employee is in the new role and it goes beyond the agreed trial period, they will lose the right to the redundancy. So rejection of offer. If an employee refuses your offer for a suitable alternative role or turns it down after the trial period, they need to have a valid reason why it's not suitable. Although it is generally accepted that it's whether the employee considers it is suitable. You as an employer cannot force employees into roles that they consider suitable, that you consider suitable. So examples of reasons could be that they turn it down, could be the job is a lower pay. Health reasons stop them doing that job. They'll have difficulty getting to the new location because the journey's longer, it may be higher cost, or there's a lack of public transport. And this would impact and disrupt their family life. So if the employee has a valid reason to turn the job down, they'll be entitled to redundancy. But as I said, if the employee does not have a valid reason for turning the job down, you could refuse to pay the redundancy pay. Okay. So avoid the avoidable. Things to remember. As I said before, you don't use redundancy to manage poor performance, as that is then at risk of being unfair selection. At the start of the process, as I said, redundancy is a proposal. Yes, it may seem like we're doing a legal dance, but unfortunately we have to go through the process. It may be that, yes, redundancy is going to be an outcome, but you never know. An employee may come up with a thought idea that you have not considered. So that is why consultation is so important. Any decision is a business decision. It's not personal and it's not a reflection on the individual's performance. Believe me, I have sat in your chairs many times. I've also been on the receiving end 3 times in my life. I know the emotional roller coaster this is. So ensure you have formal meetings. Be careful not to have informal chats. These get misinterpreted and again can lead to an unfair process for claims. Okay, Holly, over to you.
Perfect, thank you, Debbie. So I think we now move on to Alison. She is able to move herself, and we can go on to the next section. What we'll do whilst Alison
helps when I unmute myself, doesn't
yeah,
it?
there we go.
So we're going to move on to talk about probation management, which is absolutely key when you take on a new employee. And with the new Employment Rights Bill coming in, there has been a lot of talk about the impact that that's going to have on probation and being able to terminate employees without following a full disciplinary process. At the moment, we don't know exactly what that is going to look like. It looks like employers will be able to say how long the probation period is going to be, which is what it is at the moment. And they are talking about something called an initial period of employment. Indicators seem to be like 9 months, which means that during that period of time, it's likely to be slightly less onerous to terminate somebody's employment. But the important thing will be that you have managed that employee during that period of time. I mean, obviously, the idea is to make sure that the person you've recruited is successful in their new role as soon as possible. But it does give you the opportunity to manage out where perhaps you've misrecruited and the person is capable of doing the role. My advice, always sort it out sooner rather than store up issues for the longer term. So probation periods are set out in the contract. Generally speaking, 3 months is the sort of like norm. However, for more senior roles or things where you need longer to assess the employee's ability, for example, often either senior management roles or sales or business development roles, often it's currently 6 months. You can extend probation, but you should only do so obviously where there's a genuine reason for doing that, like the employee's been off sick, or you knew they'd got some pre-booked holiday, or there's some sort of circumstance, or the business actually hasn't been able to provide the training that you had intended to do. So you also have to have a genuine belief that the employee is going to be able to do that job given a bit more time. There's no point in extending a probation period if, frankly, it's blatantly obvious that the employee can't do the job and you have been providing the feedback and training that is necessary. From a legal perspective, be clear and honest. Keep notes and check the reasons if there are issues. So talk to the employees about that. And I've touched on the fact that the 2-year rule, which we currently have at the moment, will be going. Holly mentioned it. It will finally go in October 2026, when unfair dismissal claims can be made from day 1 of employment, with those caveats we're hoping around initial employment periods. So just moving on to look at medical concerns. These could be attendance and performance concerns during probation. It's around balancing the duty of care and the operational needs of the business. Once a job has been offered, not before you've made the offer, you can ask medical history related questions, usually through a health questionnaire, which is part of the offer pack that we provide or we put together and can do for you. If we do the offer pack, then we manage that whole process with you, which means that we also review the health questionnaires to pick up any concerns or anything that we think you ought to be aware of. And we can help with conversations with employees who have declared some form of health issue, which might also include mental health issues and learning disabilities. There is a duty to make reasonable adjustments for disabilities, and you must consider those sort of adjustments. Understanding if an employee has challenges up front is always helpful, because you can then plan for those and talk about adjustments. The term reasonables is key. You must consider options, but if there are good and genuine reasons for not making an adjustment that you can objectively justify, then you may not have to do so. Asking and discussing what's needed with the employee is always the best option. And it is always a requirement to don't impose your solutions on an employee. I actually have a friend who's in a wheelchair, and she went to work for a very great, well-recognised national retailer, and they were quite insistent that she ought to have a stand-up wheelchair so that she could reach shelves and things like that, and she really didn't want it. And she found it quite hard to get that message across to them that that wasn't what she wanted. So always listen to what your employee is saying. Make accommodations and be understanding, because that helps to build loyalty and productivity, which helps with your retention. Moving on to protected characteristics, I'm sure, will be very familiar with the fact that there are 9 protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy, maternity, race, religion and belief, sex, and sexual orientation. So it's very important that you avoid discrimination on the basis of any of those. You need to have objective performance criteria, and that is the best way to avoid discrimination. Documenting evidence-based decisions. So where you are making decisions about employment, probation periods or otherwise, always make sure that you document that. So there can be risks of discrimination claims. They can be something called direct or indirect. So direct discrimination arises directly out of the protected criteria. For example, not hiring or indeed firing someone because they have a disability, or because they are a woman or a man, or because they are gay, whatever the protected criteria is. That's direct discrimination. Indirect is a little bit different, because it's about a criterion or practice which would disproportionately affect someone who has that protected criteria. So, for example, requiring a driving license unless it's absolutely essential for that particular job role. And even then, there might be other solutions available. For example, the employee might provide their own driver. It could be that their partner always drives for them if they're blind or unable to drive. And particularly, sometimes that happens when there is a shorter term reason why they can't drive. So if they've had an operation which prevents them driving for 4 or 8 weeks or something like that, they may have somebody else who can actually provide the transport for them. So moving on to looking at reasonable adjustments and best practice. So identify some adjustments, things like flexible working hours, altered duties, or additional support with the work. So does somebody need a different piece of software, for example? Does somebody need voice activated software? If they might have arthritis in their hands, they can't type very well, as an example. When you need it, getting a deeper understanding and some support, for example, from occupational health. We always used to do medical reports from GPs. We're finding that increasingly difficult and, frankly, increasingly unhelpful. GPs are not occupational health providers, as they are quite often keen to tell us, and quite often will not provide the advice that we need. Consultation and communication. Engage proactively with your employee, and particularly at early stages. It sounds like common sense, doesn't it? But so often it doesn't happen. And to reiterate what we say all the time, documentation is absolutely key. So clearly record any reasonable adjustments, meetings, and decisions. You can end an employment early during a probation period if you want to do so. The things that would be considered are procedural fairness, why you've actually terminated somebody, and to isolate the review versus the holistic, looking at everything in the round. So be transparent, provide clear feedback, and do regular reviews. We suggest 4, 8, and 12 weeks on a 3-month probation period, and obviously if it's a 6-month, then those go on until the 6th month. If you are going to do this, then it should not come as a surprise to the person that you're having that conversation with, because they should have been receiving feedback and be aware that actually they're not reaching the criteria that you need them to, and they should have been getting feedback and training on those sort of things to try to correct that. Always ask yourselves, is performance being affected by the medical condition, or are they isolated concerns, in which case you would treat them differently? So we'll answer any questions, hopefully at the end, if we've got time to do a Q&A, but I'm going to hand over to Holly to go through grievances.
Thank you. Perfect. Thank you, Alison. Okay, so I've started off my notes on this slide as the dreaded G word, which for HR professionals, which I stand by that in terms of looking at the time and management and resource that it would take to deal with a grievance fairly and in line with the appropriate code of conduct and everything. It takes on average around 7 working days. If you've ever gone through a grievance yourself, particularly one that might be complex, you probably won't be shocked by that number. And do we typically see a lot of resolution from grievances? In fact, a very low percentage ends in a positive solution for all parties concerned, which makes you kind of feel as though, what is the outcome of a grievance? What is the objective? And is it positive to a working place to help your employees evolve and grow and have that engagement? And obviously, you need to have that place where people can log grievances through the appropriate channels. But what I'm hopefully going to talk to you today is that actually, how can we prevent those grievances from being filed or logged or bubbling to the surface to the point in which it does zap all your time, your resource, and actually the outcome isn't particularly positive for any of those involved. So we don't actually get a resolution even when it's gone through the appropriate channels. So let's have a little look at that. So much to sort of what Alison just spoke about in terms of some of the things may seem as though they are common sense, but good workplace practices actually really do underpin the preventative measures that we can identify really do mitigate the risk of a grievance. So firstly, sort of clear communication. So a common trigger for grievances is miscommunication. That could be sideways, interdepartmental, upwards and downwards. So making sure that we focus on our communication and updating the team as a whole as much as possible would be a good step in the right direction. I probably can't even count the number of grievances that I've seen where it's actually due to some level of office gossip, updates, restructures, behaviour, where one person or one team's been updated and the other hasn't. So trying to concentrate on giving clear and transparent communication to everybody at the reasonable time that you can do so would really go a long way in terms of preventing your grievance bubbling under the surface. Cover off any change and expected change to help manage that emotional and feeling around that as well. And also having transparent policies and expectations around how you guys can communicate within the workplace, what good dialogue look like as well. Signposting people to how you can communicate. That kind of dovetails into a positive work culture. So goes without saying, obviously, promote respect and fairness and address concerns early and informally. But as a leader within a business, you need to be empowered enough to, if you see behaviour that jars against what we've got up on the screen today, I guess you need to have the empowerment to be able to call that behaviour, that conduct out, and also lead by example. We need to be addressing those as we see them, don't build them up, much similar to what Alison's points were in the probation management. You need to deal with them as and when they arise, because quite often if you let things fester or you let an incident kind of escalate through just the natural working environment, then not only will a grievance be logged, but also you lose the accuracy of the incident. So it's really important to just kind of tackle those as and when. And then we need to think about training and awareness. So quite often as leaders, we need to promote that fairness and being a part of where you see and hear things and they're not okay, and being accountable for dealing with those things. But actually, are our managers and supervisors, are they dealing with the frontline problems? Are they equipped with the tools to have those difficult conversations, to have those challenging conversations? Can they give back constructive feedback? Do they know the protected criteria? Do they know a high level information around the Equality Act, and have they got the tools, I guess, in their toolkit to understand that if they have this conversation and it doesn't go right, what are the risks, not only to log a claim, but also for the business perspective. So we really need to think about what are we putting in place for training and awareness, and how can they connect more with HR and operational functions within the business to make their job easier as well. So proactive steps to reducing that grievance. So as I said, early interventions, addressing conflict promptly before escalation. I'm sure everyone's potentially been in a meeting or been on a call with somebody and they've seen an escalation happen and they've kind of frozen in the headlights almost, not really sure how to deal with it. It's been quite awkward. And it's about having the tools again to have the confidence to rely on policies, to rely on best practice and to do that early intervention to call out that behaviour. We would also suggest having regular feedback and reviews. So a monthly one-to-one built into your performance cycle not only obviously helps engagement and job satisfaction and growth and development, but having those opportunities to do that feedback and have those constructive feedback mechanisms in place built into the form not only helps you as a manager give you the platform to tackle those conversations quite naturally, and it can lead into a wider conversation that could reduce conflict, but it also gives you the opportunity to seek their feedback. Remember, with these things need to really be a two-way conversation, and you kind of need to use those active listening skills again, which sounds like common sense, but unsurprisingly, you quite often hear these cases and it's mainly just due to maybe one or two people not quite listening to the other person's side, and everything could have been prevented. And then finally, thinking about employee engagement and inclusion. So how often do you speak to your team around how satisfied they are in the workplace? How engaged do they feel with the purpose and the objectives of the business? Do they feel they get really great support from their managers? Do they feel they can speak to HR or leaders of the business whenever they need to? And can they express their ideas and contributions in an inclusive way? Again, all of these methods create an environment where people can speak freely. You may have heard the phrase psychological safety in the workplace, but essentially creating a culture where people have that freedom to speak professionally, but around their ideas will also prevent such conflicts that could occur that could lead to a grievance. And one other thing that we would talk about in regards to supporting grievances or even preventing them in the first instance is mediation. So mediation is a great tool to use when you feel you've got a clash between maybe two teams or two individuals, and whether it's work related or conduct related. Mediation is a great resource to tap into and has great success, more so than actually the grievance process. So what is the role of mediation? It facilitates an open and impartial conversation. To be a mediator, you have to be professionally trained in guiding and fostering those conversations between two people or two teams. And it's normally somebody outside the business. We've got quite a lot of mediators within our network. So if that's ever something that you need to explore with us, please just let us know and we can connect you with the closest and most suitable person. But having somebody external, much like Enlighten would be for your business, sometimes having someone external deemed as more impartial and unbiased helps with that helps facilitate that open conversation. Their role will be to encourage a mutual understanding and solutions around what the issue is and actually how do we get to a solution-driven place that actually both parties feel comfortable with and they can move forward. As I said, the benefits of mediation would be to reduce that formal grievance process and the related stress that goes along with that. No one has a spare 7 days hanging around in their calendar to deal with a grievance that could be landed at any point in time. And quite often when you see these grievances logged, they come to us and it will quite often be, we did know something was going on, or we knew they weren't quite getting on, or that, they did have a bit of a disagreement. Okay, we can look at this, but essentially, as soon as it's been logged, you have to then go through the appropriate channels and follow your grievance policy. Obviously, we try to always start with an informal process, but unfortunately, sometimes they've escalated so far past that point of an informal route that you have no choice but to go down the formal route. Mediation can also improve relationships and communication, better so than an outcome of a grievance. And implementing it would mean either training an internal mediator, so there's external courses you can send your internal employees on if you feel as though there's an appropriate person within your business that has the right skill set to do that. Or you can engage, like I said, with an external expert. Offering it proactively and openly is a much better approach than actually just when escalation routes occur. So really something to consider in terms of your training and preventative measures, because as I said, the dreaded G word is never a good one when we hear it land on our desk. Again, any questions with regards to grievances, if we've got time at the end, I'm happy to take some questions on that. Okay, so over to the employment law update. Obviously, we've been citing these throughout the webinar, and my slide says it is all pending. So let's look at what is likely to come into play over the next few months. Again, we are working within our network, within our professional network, and with our employment solicitors that we communicate on a weekly basis to gain the best idea of what is likely to come in. Until it's been approved, and that could be right up until the week or the day, a few days before, we haven't got a real concrete idea. So this is our best guesstimate as we see it right now. And obviously with us having that lag time right up until it, we can't actually start working on policies or changes until it's been approved. So we'll just have to work super fast and put ourselves under a nice amount of pressure to get it over the line for you guys when they do confirm. So I'll move to this slide. As you'll see, this is a timeline down the side, and a little key in the top left-hand corner, which is again a guesstimate of the impact that these changes will make to businesses, and I've color-coded each change for you to see, and we'll share the slides with you all afterwards. So for time and also consistency, what we're going to do is I'm going to kind of cover off the ones that are likely to be autumn this year, and then we're likely to do another webinar in the autumn, firstly to cover off those that have been confirmed, and then we'll start to look into 2026 and we'll have a better idea of those. If there's anything that kind of sits below those, that the first dotted line that you're particularly concerned about, pop your name and your email address in the chat, and Debbie, myself, or Alison will reach out to you after and have a conversation. But again, we don't want to over speculate and scaremonger, because that's quite a lot that happens in the media. So firstly, we've got flexible working, so medium risk identified at the moment, or impact. So currently, an employer who wishes to reject a flexible working must state which of the 8 statutory grounds for refusal it relies on. So that's as it stands at the moment, and we all know that's a day one right. The proposal in the bill is to change it so that not only do you have to state which of the 8 statutory grounds it relies upon, but you have to actually show that the refusal was reasonable. And I say reasonable in inverted commas, because obviously it's a case-by-case basis depending on the role, the business, the function and the sector. But I would say in terms of having that reasonable case periods, previous trading levels and standards. So trying to build data into that will help away in demonstrating that you've been reasonable in your approach. It's really getting that evidence across that you've dealt with that as reasonably as possible. Again, once we're in a position to post more on what that looks like, we'll be sending out some guidance. The fire and rehire is red, so that's the only one that's classified as high at the moment for this calendar year. So and it is a detailed legislation. So again, this is a very high level, and if there are further questions, we can take those. So currently, employers can generally give notice to dismiss an employee on their current terms of their employment and offer them a re-engagement on new and altered terms. Offering them a variation to contract and consulting with them. If that employee then chooses to reject those, then you would treat them as dismissed for some other substantial reason. Since July 2024, there's been an additional requirement that the statutory code of practice on dismissals and re-engagement is followed. Now, moving forward into the new rights, what's happening is the dismissal will automatically be classified as unfair if that variation has sought to vary a contract and the employee did not agree to the variation, and or where you've either tried to redeploy somebody or employ somebody else to do very similar jobs as what that they were originally doing before they were dismissed. So there's a huge risk here opening up the dismissals and the appropriate measures that you'd need to take if you were looking at doing a variation to contract. What we would suggest in terms of just preempting this movement is variation clauses within contracts need to be made a little bit more robust where possible. So that's something that we're looking at. And trying to remove the need to request the variation and more sort of impose that. But again, that only goes beyond a certain point, it becomes unreasonable. What we're seeing in terms of the conferences and the CPD that we're doing is actually if there are changes to your functions, your resourcing, your practicing, that you might think would require variations or changes to people's job roles, we are encouraging people to try to make proactive approaches to making those changes prior to these new rulings coming in, so that it doesn't make it as difficult. But that is a quite comprehensive piece of change of legislation that is coming in. And then the following 1, 2, 3, 4, 5, 4, sorry, they're in green, low impact and small shifts. So the bereavement leave currently for any of those that lose a child, including stillbirth after 24 weeks pregnant, can take up to a period of 2 weeks of bereavement leave in the 56 weeks following the loss. The time is as a weekly rate of statutory maternity pay. So the change that they're implementing at the moment in part of the bill is the right to bereavement leave is extended to those of a loved lost one. Now again, loved ones is yet to be covered in terms of set out in the regulation, but it goes beyond just a child. So that is a change in terms of what they're expecting. Paternity leave, currently there's an eligibility criteria in terms of they have to have 26 weeks consecutive service. It's going to become a day one right. So essentially opt for employer, and then paternity leave is applicable. Parental leave, the law at the moment, you're obviously eligible for parental leave once you've completed a year's service, and that's 18 weeks up to the child's birthday on their 18th birthday. The changes that that is again from a day one right, so you won't have to have that year's service. And then the final one is SSP. So at the moment, you probably all be well equipped on knowing what the SSP legislation is, but there's that waiting period, and the SSP doesn't kick in until day 4 of consecutive sick leave. This will now become payable on day 1, and the first 3 days will be payable. In addition to the lower earnings limit, that will also be removed. So that's also a consideration to make when we're calculating, particularly those on shift work or very low part-time work. The SSP rate or the 80% of weekly earnings will come into play. Again, this is all high level at the moment. We will continue to release guides and briefs and resources to cover that, but just want to give you a flavour of what's coming down the line this calendar year. I'll pass over to Debbie. I don't know if we have time for this, Debbie. I'm conscious of time, so I'll leave that over to you on how you want to manage this next slide.
Let's quickly go through the second one, because I think that's actually quite pertinent to a lot of organisations and businesses. So second one, social media workers sacked for not posting enough and making typos wins 22,000 at tribunal. So this was the case of Anita Briggs versus National Museums of Scotland. So a little bit of context. She was responsible for managing the social media content, and she failed to post any content in an entire month, and in another posted only 6 times compared to colleagues posting 73 posts. She regularly missed deadlines and made spelling and grammar errors. Now, she underwent 3 performance improvement plans, her PIPs, but was deemed to have made insufficient progress. And managers cited a loss of confidence in her ability to perform the role and dismissed her. So the tribunal acknowledged her performance was below expectations, but, and here's the big but, she was never given any formal warnings that dismissal was imminent. So as we said before, you must be explicit in your one-to-ones whenever you're having conversations about somebody's performance. What is it they're not doing, and what is the consequence if they don't improve? The dismissal process lacked procedural fairness. There was no evidence supported her claim for conspiracy to remove her from the role. So she also tried to claim that they just wanted her out, but there was no evidence to support that. But as I said, the tribunal ruled that the dismissal was unfair due to a lack of due process. and she was actually awarded £22,210.75 in compensation. So this is why it's so important for you to really ensure that you have a robust process and that you have open, transparent conversations. So as well as getting this award, you know, remember, for you guys, if you are in court, your legal fees are going to rocket, because no barrister will get out of bed or perform for less than, I would say, about £1,000 a day. So again, big cost for you to consider if you're going to get to a tribunal stage.
Perfect.
Thanks,
I'll
Holly.
just quickly interject there. I think Debbie meant £10,000 a day.
Oh, so, yes, sorry. Decimal point in the wrong place. Sorry.
So that's very favourable. The other two rulings that we've got on screen, they are really, they're really interesting cases. So because we're kind of tight time, what we're going to do is we're going to share our findings and point out some key findings and learning points from those, and we'll share those with you after with the exclusive guide. So don't fear, we haven't missed out on any information. We'll get that to you on a separate reading material. Debbie sort of prepared some stuff on that, so that's great. And then the final slide, really, well, the front slide is just taking use of the QR code that's on screen now. If you're not signed up, latest guide support, blogs, case studies that we release, then scan the QR code now and sign up. They obviously can unsubscribe at any point in the future, but anybody that's on our retainer will be receiving our monthly guide, which is really practical and helpful tips alongside any other information such as legislation changes and how we're tackling those. So I'll leave that on screen for just one more minute for anybody that wants to scan the QR code. Again, we will email these out, and they are the QR code still obviously applicable once you've got the PDF version of these slides. So yeah, leave that on there now. Perfect. So Alison, anything over to you for some closing words, and I'll flick onto our final slide in a few seconds.
Okay, I think it's really just thanks very much for your time. That's the most important thing. You know, everybody's time is very precious, so we really appreciate you joining us today. We hope you found it useful and you got some takeaways. We are here on the end of the phone. Feel free to contact us anytime with any queries. You can either drop us an email or give us a ring. So anytime you've got a query or need some help, then please do reach out to us.
Perfect. So what I'll do now, I'll stop sharing. We have got literally a few minutes. April's going to stop the recording.